All right, just a moment while we sort out the Senator Sinclair, are you hearing? We're trying to address the audio issue. Unmuting from your end. Are you able to monitor it from there?
Not right now, but I went upstairs and the IT person said that everything is as it should be.
Can you log on from here? Let me see.
I'm trying and they have not been able to. But I do have the
I'm not sure what is happening with those who are online. I'm advised that we are good from this end in the Parliament with the technology. All right. Ms. Wedderburn, may I invite you to say prayers?
Our most righteous and heavenly Father, we come before you this morning. We thank you, Lord, for the opportunity to be here, Almighty God. We ask for your presence in this meeting as we sit to consider the future of this nation. We pray, Almighty God, for your wisdom. Almighty God, we pray for your direction. We place everything into your hands. In Jesus' name, amen.
We're not able to interface with our members online, so I'm just trying to have it sorted.
Could you try it? Because I don't know what's happening. What I'm trying to look at is saying that the only difficulty is that those who are trying to speak are muted. So I don't know if you want to ask them to ensure that their mics are not muted when they attempt to speak.
Members online, can you just check your mic and unmute for me and just check in? Our mic is muted.
Good morning, hearing you.
Right. All of that, but it's linked to IT. Oh, so they're hearing the people. Yeah, she said she hearing. Oh, just so she hearing. So repeat again. Say something again. Miss Clark, just so she hearing. Could you ask somebody?
Are you able to unmute your mic from your end? I'm told they are hearing.
Yes, are you hearing me? Good morning.
Thank you, Madam CPC.
Good morning, Minister. I'm able to hear you clearly now.
I'm sorry, who is that?
MP Tamika Davis.
All right, thank you. Member Sinclair? You've printed a copy of the minutes? Do we have any apology for absence? Or lateness? Let me welcome everyone to today's meeting of the committee. The agenda is before us. We will move to confirmation of the minutes of the meeting held on February 6. Any matter arising, and thereafter we will continue our review of the bill in discussion with representatives from the Ministry of National Security. Right, page 1 of the minutes. If there is no correction to page 1, we can go to page 2. Is minute supposed to be capitalized?
I chose not to in this case because of context. Oh, no, this one should be.
On page 2, minutes to be capitalized. If there is no other correction, we can go to page 3. If there is no correction to page 3, we go to page 4. See?
That is what I included.
If there is no correction to page 4, we go to page 5. If there is no correction to page 5, we go to page 6. If there is no correction to page 6, we go to page 7. If there is no correction to page 7, we go to page 8. If there is no correction to page 8, we go to page 9. If there is no correction to page 9, will someone move for the confirmation of the minutes? Members online? Whom do we have online? If no one that is able to confirm, I will just defer the confirmation and we will come back to it. We'll also defer matters arising. and move to agenda item 7, continuation of the review of the bill, discussion of clauses 7 to 10. At the last committee meeting, the decision was taken by the committee to invite the Ministry of National Security to share perspectives on the proposed new citizenship provisions, for reason that matters dealing with citizenship fall under the Ministry of National Security. May I invite for the record this time an introduction of the MNS team.
Howard Palmer, Policy Manager, Border Security Affairs Branch at the Ministry of National Security.
Shante Booth, Head of Legal Services at the Ministry of National Security.
Tara at the Passport, Immigration and Citizenship Agency in the Citizenship Unit.
Sharika, just lower your head. No, I want to see Shante. And who is going to make the presentation?
That would be me, ma'am.
Very well. You may go ahead.
Based on what we would have presented to you as a response, I will just go through, and if there are any matters that I need to have clarified, I'll ask my colleagues who are the citizenship experts to jump in as, excuse me, as necessary. Section 7 of the Constitution as it relates to the deprivation of citizenship, the First Amendment, where there is, we propose the inclusion of a provision allowing DNA testing to establish descent, as is done in most advanced countries, increasing the sophistication of fraudulent document creation and the inability of foreign governments to authenticate birth records compromise citizenship investigations, as document forensics must prove
Ms. Booth, I'm not necessarily asking you to read it, but just to take us through.
Okay.
Right.
So, in a general sense, in summary?
Well, not just in summary, but clause by clause that you are making the comment on.
So, the deprivation of citizenship commentary first.
Just a moment. Yes?
The commentary really surrounds the introduction of using DNA to establish descent as a supplementary element to the documentation process that we currently use. There is also a question as it relates to the conditions for deprivation of citizenship. There is a potential conflict with the Nationality Act where section, if I may, Section 11, thank you. Section 11 allows an appeal for deprivation of citizenship to the Supreme Court. Oh, 8. 8.4. My apologies. So that is one concern that we shared. We also believe that there should be an exception to the grounds of the provision of citizenship where somebody has been found to commit a serious offense such as terrorism, etc. Currently, there is no such exception to the provision of citizenship as proposed. And then section 10, where we seek to amend section 12, this is a matter that has multiple or far-reaching effects as it relates to other acts of parliament, namely the IRCC and the Nationality Act, but more specifically the IRCC Act, which is the Immigration Restriction of Commonwealth Citizens Act. So here in the current, based on the proposed amendment to change the definition of alien to include all non-Jamaicans and exclude members of the to include members of the Commonwealth in that definition, well, exclusion, I should say, the IRCC speaks to special treatment and special exemptions as it relates to immigration for members of the Commonwealth currently.
Miss Booth, the essence of the submission from the MNS is to ask for certain things to be included in the constitutional amendment and to point out what is included, how it conflicts with existing law. Is that the essence of it?
There are, I would say to a certain extent, yes, ma'am.
All right. And you're asking for the Constitution to prescribe the use of DNA verification for citizenship by descent?
As a means to verify if there are questions of fraudulent activity.
And you're asking that that be placed in the Constitution?
There has been a discussion at the MNS level there are two views. One is that it can be placed in another piece of legislation or regulations or in policy, but at this juncture, that was the view that was taken by citizenship experts, ma'am. We will yield if it's not seen to be fit to be in the Constitution.
All right. Clause 8 proposes to repeal and replace sections 9 and 10 of the Constitution and substitute the provision there. Proposed section 10, 10C, provides that subject to the provisions of this chapter, that's the chapter dealing with the citizenship, Parliament may make provision prescribing the grounds on which and the procedure by which a person may become a citizen of Jamaica by descent. Can you share your comments on that provision vis-a-vis what you are asking for inclusion?
I believe that would cover our proposal, as we know that Parliament can make subsequent acts to deal with that procedural matter, ma'am.
All right, so we don't usually put details or administrative matters in the Constitution. We put the very broad principles and we set the framework and the limits for other laws. So by prescribing or providing that Parliament may make provision subject to the provisions of the chapter on citizenship, prescribing the grounds on which and the procedure by which a person may become a citizen of Jamaica by descent, would allow for any procedure that can be legally and constitutionally accommodated to be done by way of a law. And since the Ministry of National Security has subject matter responsibility for citizenship and immigration, then the ministry would formulate the policy that would go to cabinet for approval, and from which drafting instructions would be prepared and be issued for the law. So this matter is not a matter that would be included in the Constitution, but if it is a matter that the ministry believes is important, and that would have to be discussed at another level for many other reasons, then that would go into your policy first and foremost for approval by cabinet, and then for instructions for the provisions that the Constitution is empowering the Parliament to make to deal with the grounds on which and the procedure by which a person may become a citizen. So it's important to understand how the laws are made and what is appropriate at what level.
Thank you very much, ma'am. That was a discussion that was had in terms of where would be the most appropriate place to have the matter addressed. But thank you very much for that.
Right. So the proposal for inclusion in this bill that is amending the Constitution to allow for DNA testing, that would not be the appropriate place for
Agreed,
that
ma'am.
proposal. All right? Yes.
Morning. Thank you very much for that. What exactly exists currently in terms of DNA testing for citizenship? That's not a protocol at all that is in place? And is there any sort of legislative support for that?
I'll let Ms. Brown, she's the head of citizenship at PICA, answer that question.
Not aware of anything in legislation that deals with that, right? That provides for the provision of DNA reports to substantiate claims to Jamaican citizenship by descent. So through lineage currently, we established that process using the civil documents, the birth certificates, etc.
Okay. So you're not currently, there's not even a process now for that to be done voluntarily. If somebody wanted to submit themselves, they couldn't do that now?
Generally speaking, no, it's not the norm currently, but of course you may have an exceptional circumstance or a case whereby perhaps that could be considered if there is an element of, say, a doubt perhaps, and you want to establish that claim, right? Then perhaps the person could bring in such a report that would also be looked at in support of the application. But it's not widespread. It is not something that is generally done.
Thank you.
I don't know if the MNS team was listening, but the inclusion of a specific provision to ensure that the grounds on which and the procedure by which a person may become a citizen by descent is a direct response to concerns raised to us in our consultations with members of the public, and in particular, Jamaicans who reside abroad. And there seemed to be a gap in the law. So to make it clear that although you can acquire citizenship by descent, there needs to be a proper legal framework for the grounds on which it can be done and the procedure by which it can be done, because a matter as important as this cannot be left to unguided discretion, as it were. All right? So any matter that would assist in ensuring that the grounds are properly set out and the procedures properly set out is a matter that the MNS would have to deal with within the ministry and for the law to be passed. But constitutionally, a provision is being made empowering the Parliament to pass laws to deal with this matter. All right? The other matter that you have raised about deprivation in case of marriage is also a matter that would be more appropriate for primary legislation. So your proposal is that the legal framework should include a provision that would deprive anyone who has acquired Jamaican citizenship by marriage where fraudulent documents have been used, or where it is a business marriage, as it were, primarily for the purpose of acquiring citizenship and not because there is a marriage in substance. All right, so this, again, is a matter that would be more appropriate for primary legislation and not the Constitution. But please go ahead.
I would just like to clarify, that was also something that was brought up in our discussions. It is just for clarity, because it says subject to the provisions, this is C. So as you have rightly said, this is something, as it relates to procedurally, that should be dealt with in primary legislation. But it says, except where A, B, or C.
No, I understand.
Yes.
Currently, the Constitution says that if you acquire citizenship by birth, by descent, or by marriage, you shall not be deprived of it.
Yes, ma'am.
If Parliament is to pass a law making deprivation, then the Constitution would have to allow for deprivation to be done on certain grounds that Parliament would thereafter set out. So this would require an amendment to the provision that is being put in the Constitution, because currently no deprivation can be done if you acquire it by citizenship. It's by marriage. There are three grounds on which, among the many grounds, there are three by which you cannot, if you acquire citizenship by birth, descent, or marriage. Currently, the provisions say you can't be deprived of it, but you're saying that you would ask for that to be subject to Parliament passing appropriate law, setting out an appropriate reason.
Yeah,
and you have given an example of
and
that
perhaps
reason.
an exception to those grounds being excluded from deprivation then.
May I just ask, what is the prevalence of this that you see within the department dealing with these matters?
In both grounds, fraudulent business marriages solely for the use of citizenship, as well as fraudulent documentation that is used to apply for citizenship by descent. So I'll allow Mrs. Brown to speak on the prevalence.
So I would ask that you deal with each separately. So currently, for those who are listening, a person can acquire Jamaican nationality by descent, but we have no guidance on what that is. And right now, it is dealt with administratively within, is it PICA? PICA. And that has created problems, and it has also created opportunities. And we know that the Jamaican citizenship must be treated as special and rare. But we also know that it is customary for us to utilize persons who are entitled to citizenship by descent to represent Jamaica in the sporting arena, nor reggae boys or reggae girls, and even for the World Championships and Olympics. And Jamaicans feel very proud of that. But we also know that citizenship can be abused. And we currently have no limit to the extent by which you can acquire citizenship by descent. And the question arises in these amendments whether that continues to make sense, whether there should be some limit, generational limit. We have prescribed 3 generations for anyone who is nominated to hold the office of president to no further than a grandparent. I note that your submission is asking for a similar cutoff. Well, let us hear why you believe that that is appropriate. 4 generations, and for jurisdictions that have a generational limit, have you looked on them? What is it? When I took a look, most go to 5 generations, 4 or 5 generations. But let me hear from you.
Here, can I just ask in your response, currently we can go back as far as we want to go back in terms of determined citizen? Well, yeah, please respond to that.
List, right? So as long as an applicant is able to provide the documentation in support of that application, then the citizenship by descent is granted. What we have found is that increasingly the documents, right, we have been exposed to a number of persons, I would say, trying to defraud the system by way of providing documents that are fraudulent to support their applications. The further back we go, it becomes increasingly difficult to provide those civil documents that we need to trace and establish, that claim. So this is why, part of the reason why we are suggesting that perhaps consideration could be given to the inclusion of that clause, right? So that we would not have citizenship by descent limitless according to generations. And of course, I suppose this is where the argument too earlier for the DNA testing would come in, because where a person, is unable to provide supporting documents for such an application, then the DNA testing could perhaps be utilized in that process and perhaps would give a more accurate, I would say, right, support for that application.
If I may, in relation to that, I like the way the chairperson has put it in context that the Jamaican citizenship is something that is cherished and treasured. Currently, we use a document-based system to establish citizenship. And these civil registry documents have little to no security features on it. And so we are vulnerable to manipulation by transnational criminal organizations and their operatives in getting Jamaican citizenship in lieu of not only staying here, but to compromise other border security, other nations' border security, using the facility of our Jamaican passport. And so it is important for us in a modern age to implement modern technology and facilities to secure our sovereignty and our citizenship. And so that's why the ministry, having evaluated the system, the current system as it is, would seek to have stringent measures in place. So when you have something where a person can claim that they have a Jamaican parent from 1800s, the civil registry documentation, there's no way Peacock can be able to verify that this documentation is correct, and the country from which it's coming from will also tell you that their civil registry is unable to verify the veracity of the authenticity of this document. And so we are left compromised in that regard, so that by default that citizenship is in doubt. And so we're left in a conundrum of how it is that we establish it. So having a cutoff point would mitigate some of those vulnerabilities in that regard.
I find it curious that somebody could actually have birth records from centuries ago. I mean, I can't remember who keeps that kind of documentation. But wasn't there, I recall when the RGD turned to the new, I call it the new birth certificate, it's not so new anymore. Wasn't there a call and a requirement that if you had older documents, you had to come in and authenticate them and get a
a birth certificate in the new regime with the security features. So I was under the impression that the system, our collective national system, was no longer accepting these older records.
Yeah, interestingly, in relation to that one, it is not necessarily the Jamaican document that is the problem. We have a very good civil registry system where the RGD can track back down to the source register of that red document that most of us will have known from back when, the pink slip as they call it. We can track ours, but in relation to the person who is claiming from descent, their civil registry is unable to verify the veracity of those documentation and the information on the document itself. Okay. So that is where the vulnerability comes in. So somebody will use a Jamaican document and then forge a foreign document to align with the names that are on the Jamaican document to claim citizenship.
I see.
Yeah.
Can I ask you, even if you don't have it today, at some point, could you submit to the committee, just give us an idea of the kind of numbers that you're seeing who are seeking to perpetrate this kind of fraud in the system? What does your data look like? I'd be interested in seeing that. But I quite frankly, Chair, I'm inclined to support an amendment in relation to descent and marriage, given the reasoning. We could interrogate it some more at the end of the day, but
let's go through
something that I'm empathetic to.
What I'm hearing, I think it's important for all who are listening to understand the rights and responsibilities of citizenship and the obligation of the state towards its citizens. Once that is properly and sufficiently understood, then I think it would allow for an appreciation of the concerns about protecting your realm. In terms of taking great care on how citizenship of the state is acquired. All right, so what I am hearing, and we need to go further into the justification, is that there is, the MNS is of the view that there is a proper place to allow for the restriction of citizenship on the 3 grounds that are now prescribed as automatic grounds on which you can get citizenship and from which you cannot be deprived of citizenship. All right, so let's just go back now. Can you share with those who are listening and with the committee what are the obligations of the state through PICAs? What are citizens of Jamaica entitled to from the state of Jamaica?
Also,
please always wait for the red mic.
I'm sorry.
Start again.
Okay, right. So we are guided by the Constitution, which grants persons Jamaican citizenship by virtue of birth, right? Of course, that is the responsibility of the RGD.
I'm not asking you now about how would the person acquire citizenship. My question is, what are the entitlements of a citizen of Jamaica once someone is a citizen of Jamaica, by whatever means they have acquired it lawfully? What are they entitled to?
Right. So once you become a citizen of Jamaica, then you're entitled to everything that I, a Jamaican, would be entitled to. I'm a Jamaican-born national. So I have a right to register to vote, right? I have a right to apply for...
Just a minute. I'm asking you from PICA's perspective. I'm not asking you from a general perspective. So the right to be issued a passport...
But it's a passport. Oh, I didn't know it was that narrow.
No, I'm asking from your perspective. There's a reason why MNS is here and not ECJ.
Okay. I thought, I'm sorry.
No.
I thought
you have raised issues about security.
Yes.
Right.
Right.
Which only your team can offer the perspective into. if we are going to limit the right on security grounds, it's important that we hear what those are.
Okay.
So I'm beginning the discussion by asking you first, what are the entitlements
Yes.
that would impact security and why?
Okay. So a person who has been granted Jamaican citizenship from a PICA perspective now would be entitled to the right of an application for a Jamaican passport. Also, that person could also be entitled to an application for an unconditional landing stamp in a foreign passport. Currently, those are the two main things.
Just a minute. Let's go to the passport issue. What is the significance of having a Jamaican passport or a passport generally?
Right.
We can't take these things for granted. We're making laws, right? So you can't assume that everybody knows, because we have to have a record of it
Right.
through the lens.
So the passport now would entitle, it's one, a form of identity, right, for that person, as well as a travel facilitation document.
And what does the passport entitle the holder to when you travel?
Well, it entitles the holder to entrance to countries where there are no visa requirements, say for Jamaica with that particular country, right? It also enables that applicant to apply for visas for particular countries and for the visas to be placed in that particular passport.
And in the event that someone who holds a Jamaican passport is overseas and, say, gets into trouble or loses the document, what are the obligations of Jamaica to such a person?
Right, well, such a person will need to ensure that that is reported to one of our overseas representatives, say a high commission, embassy, or a consulate general, right? Because they will also...
So, hold on. So they are allowed to make a report to the embassy or the high commission. All right? And let us say that they find themselves in a jurisdiction where we have no embassy or high commission. What would they be entitled to as a Jamaican citizen?
If there is no Jamaican consulate or high commission there,
What is the duty of the Jamaican state to such a person?
To protect that person.
All right? So recently we had people in Ukraine, when war broke out in Ukraine. We don't have an embassy in Ukraine. What were the responsibilities of the state for those who say, I'm Jamaican because I hold a Jamaican passport? And what security considerations? What I'm inviting is an interrogation of the matter so that it is clear why a restriction would be justified or is justifiable. That's what we need to probe. We can't take for granted that the knowledge you have is shared by everyone or shared by all parliamentarians, right? Laws have to be grounded in proper evidence, proper policy, clear policy that is verifiable. Mr. Palmer?
Okay, Mrs. Brown has been speaking from the citizenship perspective, but there's an immigration aspect to it that needs to be observed. First of all, a Jamaican citizen has the right of freedom of movement in and out the country, unrestricted. And that is something that is very important. So, for example, we saw in COVID where persons were on a cruise ship and they wanted to get off to come into the island, and because it came an issue for that person to be denied entry to the island, that would be unconstitutional, because as a Jamaican you have the right to access to your home.
All right, just to say that none of the rights is absolutely guaranteed.
I know,
Right,
I know.
But yes,
yeah,
there is a right to enter in and out of Jamaica and to move around freely in Jamaica.
exactly.
Right.
That's
And
why you
that
belong.
right is enjoyed to the extent that it does not prevent another person from enjoying the same right.
Yes, exactly. The public safety factor. Also, no, this is where it gets interesting. A person who gets citizenship by descent and they go to another country and they commit heinous crimes, they can choose to be deported to Jamaica and being the holder of a Jamaican passport. The Jamaican government is obligated to accept that person because they are a citizen of Jamaica. Additionally, when that person who is a foreign national...
Just a minute. So it's important, again, to understand that where a person holds Jamaican citizenship, even if that person also holds another citizenship, in a case where that person is subject to deportation, that person can invoke their Jamaican citizenship and be deported to Jamaica.
Yes.
Even if they have no connections, other connections to Jamaica, they have no family members in Jamaica.
Yes.
And we have examples of that?
Yes.
All right, so what is the prevalence of that situation?
It is quite prevalent.
All right, so quite prevalent is qualitative and does not tell me what that means.
No.
So if you can assist by saying how many persons are deported to Jamaica, and of the number, how many you have either suspected or concerns of, because those of us who are on the inside know that this is an issue, but people on the outside may not know. And what then is the impact on the obligation of Jamaica to someone who has acquired citizenship by descent or any other means, but has no other connection to Jamaica, was not raised in Jamaica, was not socialized in Jamaica, but in the worst case scenario, invokes the Jamaican citizenship, and the state of Jamaica and the people of Jamaica are left with the burden of taking care of that person.
Yes.
I think that is what needs to be communicated clearly so that we can have an understanding of the importance of the ask you are making, to say that the Constitution itself must allow the Parliament to make provisions for the deprivation of citizenship by descent or marriage. You've even said by birth too. Well, others have submitted because they're saying if, for example, someone just happened to born here with no other connection, they're passing through, and they're entitled to others. I'm just telling you, others have submitted on that. But go back to descent and marriage. You're saying that there is a proper case to be made for the Constitution to reserve a power to the Parliament to pass laws to make provisions for the deprivation of citizenship in appropriate case where the national security of the state is at risk.
All right.
And public safety is at risk.
So the matter of statistics, based on the short notice that the ministry got, were unable to garner those.
So your answer would be that you would be asked to be permitted to check the stats and report back.
Yes. But just to give you another scenario, because this is, as I said, from an immigration perspective, this is far-reaching. I'll give you another case where, for example, we have a case right now. A Jamaican mother, a Jamaican citizen, went to Bahamas, was working in Bahamas, had a child in Bahamas. Based on Bahamas' constitution, they are not entitled to citizenship just by birth until they reach the age of major, then they can apply for citizenship. That same Jamaican mother now went to the United States with her child, where the child became a permanent resident there, has committed himself, and is now being, the U.S. government is deporting him to Jamaica, even though he's not a Jamaican citizen, but he can claim Jamaican citizenship by his mother. So we have to protect ourselves from those type of cases.
So from a security perspective, tell me about your understanding of statelessness, because someone has to have a citizenship somewhere.
Yes.
And you're saying in that case, where he was born in Bahamas, the Bahamian provisions do not allow automatic citizenship by birth.
Yes.
And because Jamaica allows it by descent, but that person has never lived in Jamaica, and Jamaica has not had the benefit of good citizenship from that person, but now must be left with all the burden of a criminal convict being deported from a place where he was raised and perhaps acquired his criminal socialization.
Yes.
And then they must be unleashed on the Jamaican people.
Yes.
So you have said many things. You have identified an example of a jurisdiction where citizenship is not automatically acquired by birth.
Yes.
All right, so I'm going to ask the research team to just look at how many countries in the community of nations where citizenship by birth is not automatic. And we have to bear in mind that Jamaica has a different cultural experience too, because there are multiple factors that we take into account in making provisions. So that's one. You're saying that the person has had no real connection to Jamaica because the mother has not lived here. You didn't say whether the father was Jamaican.
No, we
No.
don't know that. No.
No, don't know. But that person has gone to the U.S. and lived there between the Bahamas and the U.S.
Yes.
And the only time now Jamaica is coming into play is for him as a convict.
Yes.
And I don't know what level crime, serious crime, heinous crime.
We didn't get the details
All right,
of the crime.
but a crime that has the consequence of deportation,
Yes.
and that he's to come back to us. And then the state must now direct the resources away from Jamaicans here to take care of this person.
Exactly.
I see. And you say that there are numerous examples within the system where Jamaican citizenship is being invoked by descent for the purpose of deportation, having somewhere to be deported to,
Yes.
after the person has been convicted and sentenced. I see. Yeah?
If I may, Chair, one of your earlier questions was asking why did we propose that the limit should be set to one grandparent, as the same has been applied to anybody nominated for the
Just to
for the
tell you, you're
post.
going to have problems with that, because
Okay.
grandparents are younger and younger, right? So you have many generations, and people like their Jamaicanness, okay? And those amendments were made at a time past when there were a lot of difficulties around, people being abroad. But let us hear the argument, and then we have to weigh them as legislators, right?
The argument would be similarly to what Mr. Palmer discussed, the matter of documentary verification. As you said, the further we go back, the harder it is to verify foreign documentation. And Jamaica, I must say, is far ahead of its compatriots in the Caribbean as it relates to a civil registry system and documentary safety features. So I do understand as well, I said it to Mr. Palm in our discussions, that one of the things that we are able to utilize through citizenship by descent is having representation at varying international sporting events. So secondly, as an attorney, I like consistency in the law. So perhaps somebody could argue, why is it that the president's or anybody nominated for president's descent is limited to a grandparent? However, anybody else can go as far back as 5 or 4 generations. Just for consistency and transparency, that would be my argument, to have a consistent means of, a consistent cutoff time for descent. So what's good for the goose may be good for everybody else.
We hadn't finished the immigration matters. So the person who gets a Jamaican citizenship and the passport by descent, their children are now entitled to Jamaican citizenship through that. So previously they have absolutely no connection to Jamaica, but somebody found that they had some connection. Though their children and their children's children now have rights to Jamaica through citizenship by descent.
Let me translate that. You're saying currently, a person who acquires citizenship by descent can then turn around and pass on that citizenship by descent. And there is no limit to it. And that poses administrative and other difficulties. Administrative difficulties in verifying documentation, and in worst case scenario, Jamaica having to bear the burden of someone who chooses to exercise the rights of citizenship in a case where that person is convicted and is subject to deportation. Let's see. All right. Any comments from the technical team? Yeah?
Given the proposed amendment to the removal of the Commonwealth from the Constitution, has the Ministry of National Security gave any thought to either combining or subsuming the Immigration Restriction Commonwealth Citizens Act into the Aliens Act, since there would be no constitutional distinction between an alien from a Commonwealth country and an alien from a non-Commonwealth country?
All right, before you answer that, when I went through the memorandum from the Ministry of National Security, something struck me. Maybe it's how it is set out, that there isn't a sufficient appreciation of the lawmaking process. So you raise as conflicts, existing conflicts or potential conflicts. But what has to be understood is that if changes are made to the constitutional framework, which makes existing laws inconsistent, then those laws also have to be changed. And this is among the many reasons why we choose to do the reform in phases, because we cannot do it all at once. And we have had examples where the constitutional provisions have changed and the follow-up work to the laws, the primary laws, have not changed in time. We have seen that with the Charter of Fundamental Rights and Freedom, and we cannot continue that. So for all who have been questioning the wisdom of the phased approach, I use this opportunity to reiterate that it is well thought out. So the proposal, for example, to amend the definition of alien to now mean a person who is not a Jamaican citizen will require changes to the legal framework for Commonwealth citizenship and those who are properly regarded as aliens now. And that is a lot of work. And we cannot make change at a pace that will throw our system into unworkable chaos, because fundamental rights flow, and where rights are guaranteed, they must be honored, and we have to ensure that we have the provisions in place. So just to point out that among the reasons that you're called here is not just to hear your view, but to make it clear that from these proposed amendments, the work to change the framework is going to be big, and it has to start from now. And we have been told that the two primary pieces of legislation have been under review for a long time. Right? So the Immigration Restriction, the Commonwealth Immigration Restriction Act and the Aliens Act. That entire framework will have to be overhauled. So the question from Mr. Brown is whether you have considered that and the extent of the work that needs to be done, and also how the path that you are proceeding on now will either be consistent with the proposed changes or be in conflict with the proposed changes. to the Constitution?
That was considered, Chair. It was something that was discussed, and not only will those two primary pieces of legislation be overhauled, but there is a contemplation of simply consolidating all immigration-related matters into one primary piece of legislation to allow consistency and continuity. So we sought to raise it here because procedurally, especially the Passport and Immigration Agency, PICA, while legally we understand that once the Constitution is in conflict with any primary legislation, it is in fact supreme. Procedurally, that may, if we're not able to keep pace, that may cause some procedural challenges, not may, but likely will cause procedural challenges, especially in the newness of the change.
Ms. Booth, I want you to rephrase it as a lawyer. So I want you to rephrase that because I don't think you fully understand. Let me take liberty with you, what you have just said. All right? The Constitution is supreme, and any other law that is inconsistent with the Constitution is null and void to the extent of the inconsistency. That has to be understood by every official in government. You can't have any policy, any process, and any procedure that is inconsistent with the framework of the Constitution.
Very interesting. Just on the point of the two main immigration legislation, we have been working as part of the amendment to ensure that there's harmonization between the Aliens and the Immigration Restrictions Act. So this definition change, proposed definition change, is welcomed because this would advance the amalgamation of all the two legislations into one. So we are far advanced in that regard because we have been having the harmonization of the two legislation. But in furtherance of that, we have proposed for the removal of those special privileges that have been named in the Constitution in the current Constitution. For example, to Commonwealth nationals and the Republic of Ireland specifically, because they are anomalies and they have raised serious issues in relation to especially the Republic of Ireland recently, where they were contesting if they are alien or Constitution or Commonwealth citizens, and based on their own definition, they're really neither falling under either pieces of legislation because they have declared themselves not to be Commonwealth, but they're not based on our Constitution and legislation, they are Commonwealth citizens, so they're that type of anomalies that we need to iron out in these.
Let me explain what that means to those who are watching and listening. Where the Constitution makes a specific provision for something, unless the Constitution is changed, it is what is. And the Constitution lists Ireland, is a Republic of Ireland, as a member of the Commonwealth. Well, citizens of the Republic of Ireland are treated in a particular way. Let me just pull up that. That's section 11. That's section 10 now. A Commonwealth citizen who is not a citizen of Jamaica or a citizen of the Republic of Ireland who is not a citizen of Jamaica You're talking about the current section 10 of the Constitution. Or 12? 12. Foreign country means a country other than the Republic of Ireland that is not part of the Commonwealth. So by virtue of this, the Republic of Ireland would not be regarded as a foreign country. And you're saying the Republic of Ireland has what?
They have contested the visa imposition on them because they say that they are not an alien country, they're a Commonwealth. They're not a Commonwealth and they're not an alien country, so the visa doesn't really apply to them. They're a special nation. Exactly. Would not apply to them.
Well, I don't know that that argument has any weight, because we are a realm country and we need a visa to go see our head of state.
All right. So, for example,
No, I cannot. No, the argument is correct.
Yeah.
By virtue of how they are defined in the Constitution of Jamaica, they are not a foreign country. We understand that.
Yes.
But neither are we a foreign country to the United Kingdom. But we have no freedom of movement there.
Yes. The AGs has ruled on it. The AGC has ruled on it.
To say what?
To say that they are, as the immigration department, immigration unit has imposed the visa on them, they are adhere to those.
Absolutely.
Yes, but I'm just saying that they raised some valid points.
Yes.
And so we would like to take away those anomalies and those gray areas to ensure that everything is streamlined.
I'm just trying to look at our proposed section 12.
Okay. So in section 12, we had not opined on our bill hasn't opined on the Republic of Ireland matter. Okay, thank you.
It has in a way because of the changes to the definition.
Of alien, yes.
So it has, all of those matters are now simplified. Because when the changes are made, a foreign country would be a country other than Jamaica.
Yeah.
But even within the Commonwealth of Nations, visas can be imposed.
Yes, the minister has the power to
because
impose visas.
We have countries that have no shared heritage.
Yes.
But generally speaking, within the Commonwealth, special consideration is given to treatment of Commonwealth citizenship.
Yes.
But not all countries
No.
have maintained the consistency.
Yes.
What has happened is that their national security takes priority. Their national interest has taken priority over community interest.
Yes.
Or the grouping interest.
And we have also made it similar for British dependent territories and British protected territories, which are also given special treatment, immigration treatment, for those to be, if they exist in the current proposed changes, that they be removed as well. Yeah. No, just pointing out to them.
All right. So you have asked us in respect of the descent and marriage, and in respect of birth, you had referred to, let me just see, this is not readable. So you have said that you would ask for consideration to be given to non-automatic citizenship by birth if there is no Jamaican parent? Paragraph. Similarly, an exception should be made for individuals born to Jamaican parents in another state who were not granted automatic citizenship based on birth but are later deemed Jamaicans following the commission of crimes, particularly those warranting deportation. In line with the conviction exemption clause, such individuals should be subject to deprivation of citizenship.
That is one of the cases I highlighted before.
But what I gathered that you're saying is that even though there is an entitlement to citizenship, if the entitlement is being claimed in a case where the person has no connection to Jamaica and is only at a time when they are subject to deportation, then a discretion should be reserved to the state to not issue the grant of citizenship.
Not only
in those circumstances. Which,
Madam
yes.
Chair, not only in the deportation cases, but also where the investigation has found. So as part of applying for citizenship, usually by procedure you have to provide a police record. Now we ask that the minister have that discretion to deprive the person where they find that this person claiming citizenship to refuse the application because of the public safety
All right, so
issue.
you're really asking for a carve-out for consideration to be given to the circumstances under which the entitlement to citizenship is being claimed.
Yes.
And you're also saying that we operate on a documents-based system, and the further back you go, is the more difficult it is to verify the authenticity of the documents, which then makes the entire claim questionable.
Yes.
So you're asking that consideration be given to limiting how far back you can go, because it's already a problematic area.
Yes.
All right. That's a matter that we will have to consider, how far back, because you're asking for third generation, and I know that that view is not going to be shared by everyone. But it does seem as if there's a proper case to say it should not be limited, limitless. All right. Is there any other matter that you wish to raise? Because the majority of the matters will have to be dealt with internally after the changes are approved. Anything to be flagged?
Just the power of the minister, which would, the Constitution would negate the power of the minister under Section 11 of the Nationality Act for him not to give a reason for his deprivation of or deny citizenship to of an applicant based on security reasons, that he doesn't have to give justification neither in court.
So the Parliament has to balance that. Concerns have been properly raised about blanket discretion under the rubric of national security. While there is a proper place to restrict disclosure of information on the ground of national security, the Parliament also have to guard against abuse of invoking national security as a ground where there is no justification. So when we sit to make law or we sit to formulate policy, we have to balance a number of things, all right? So worldwide, defense of your realm is something that has to be taken seriously, right? And there is a proper carve-out for exceptions as they relate to matters of national security. But we also have seen a number of cases where that is abused. And the question for us as legislators is what would be the right balance. So the highest we can do at the level of the Constitution is to empower the Parliament to make the provisions. And when those provisions are being made, is for us to scrutinize it. So what I take away from your ask is that the acquisition of Jamaican citizenship should be subject to procedure, and it should be subject to grounds. So in the same way that even when you're born here, you still have to go through a registration of birth in order to verify. All right. Philip?
Thank you, Minister. So stemming from that discussion, in the submission from the Ministry of National Security, they had flagged in relation to this Section 8.3 as proposed, which is Clause 7 of the bill, and whether that would conflict with Section 11 of the Nationality Act. Now, the issue there is that Section 11 of the Nationalities Act says that the minister's decision, that is to deny an application, shall be final, whereas Section 8.3 speaks to the fact that Section 8.3, as proposed by Clause 7, says that a person who's aggrieved may apply to the Supreme Court for redress. So, in considering that, the question that we have is whether there really is an issue there, because when we look at Section 11, it speaks to an application as opposed to deprivation. So in other words, the person is applying for something and being denied, and in that case, the minister's decision is final, versus a person who has citizenship being deprived and thereby seeking a right of redress in the Supreme Court. So in that sense, I was wondering if the ministry could clarify if there is a conflict at all, given that Section 11 is speaking to application and not deprivation.
Well, unwittingly, you have helped to clarify it for them, that there is a difference in the provision, that what is proposed here is addressing a case where the person is already a Jamaican citizen and is deprived of it, as opposed to a case where someone is seeking to achieve citizenship and has not so acquired it. But then the wider question is it proper for no reason to be given? Or under what circumstances would it be in a proper case for no reason to be given? National security, to what extent?
Thank you, Chair. That question was actually posed, but we wanted the clarity here because we did think about it in that the section speaks specifically to an application being denied, but I wondered if some creative attorney could see deprivation as a means of essentially denying something. So that's what I wanted here, because I could see that being posed to the court.
Well, Ms. Booth, you are correct, because if they say in the current formulation, I am entitled, and all I need to do is to go through administrative processes, and you deny me from going through those administrative processes to acquire what I'm entitled to, then that in effect amounts to a deprivation.
Right.
So the point is well raised, and it does require some clarity. If the proposal, if the recommendation is accepted that there is proper place for a reservation of power to the state to deprive citizenship or to refuse it, then the entire framework would be changed. All right?
Thank you very much, Chair. Another matter that came to mind, although it's not directly presented here, having a right of redress to the Supreme Court, I'm just thinking broadly now, administratively, we understand the limitations of the court. Is there, and that would probably be through primary legislation, but is there any contemplation of having a specialization? Because we do understand as well that time frames in relation to these matters immigration matters are often very important. And we know that the usual time is not particularly quick, and there is no particular right to a quick citizenship determination process under the law currently. So I'm wondering if there was any thought given to that, because now this will be another thing that the Supreme Court has to deal with and people have a right to, that is enshrined in the Constitution. So I'm just wondering, because this is linking
I suspect you're making the link that the state may want to take action to deport someone, and if that is done, it may create some other issues, and security reasons may require quick deportation from the jurisdiction.
Correct.
And we have had cases like that recently. I mean, in my former role as Attorney General, I dealt with one that had to do with someone who came into the jurisdiction after being accused of committing a heinous murder. And the matter ended up before the court. So, yes.
That did bring to mind, because once the court has not determined, you have you have a right to remain.
But what has to be understood is that the Constitution guarantees due process and protects it. And everyone who works in government as an official must have an appreciation for due process. All right? We can't get around it. Many have been getting around it and have been delegitimizing the state. But everyone who works in government must understand the importance of rights that are guaranteed and how those rights are to be treated, and the importance of due process. It mustn't be seen as an inconvenience. So if our systems have to become more efficient so decisions can be taken in a more timely way, then that is the work before us, not to decry the due process. Right? All right, so this exchange has been useful, but we will still ask for you to check the stats and come back to us so we get a sense of the prevalence of the problem. And we know that we can't look at it just quantitatively, because one case qualitatively can have a massive impact on security issues and in turn the safety of our nationals. And we also know that we are dealing with the consequences of the new executive orders that have been made by our neighbors to the north. And our jurisdiction has to prepare itself to deal with people who will be involuntarily returned to Jamaica. And those may involve persons who have committed serious criminal offenses and who have no connection to people in Jamaica. They have no home to return to. They have no family members to hold them up. And the state will have to bear the burden of dealing with them, because might is going to be right. Yes.
One of the team might have touched on this earlier. There was a reference to those persons who are stateless. Or it might have been you who made that reference. In the scenario where the United States, for argument's sake, as they seem to be contemplating, instituted a situation where there was not citizenship by birthright as of right. A person being deported from such a country, and I know there are a few countries where birth does not deem you a citizen. There's a process usually when you get to the age of majority or something like that. If a person like that were being deported, and let us say we too took the position, as you are proposing, that by virtue of descent, this person claiming citizenship by virtue of descent, because of having committed whatever crime, is going to be denied citizenship in Jamaica. What happens to that person in the global community? Where do they lie? Who is responsible for them? What nation state do they attach to in that sort of circumstance? That's my first question. And when you talk about, my second question, I'm going to give them both. My second question, when you talk about being able to promulgate laws to deny citizenship or revoke citizenship in cases of descent and marriage, in those circumstances where persons have committed terrible crimes, are you talking about the denial of citizenship only for crimes committed in Jamaica or for crimes committed in other jurisdictions that you may become aware of?
Just before you answer, one of the questions that popped into my head when you ask the first two questions is, should Jamaica bear the burden when other states do not wish to, if someone is also entitled? Yeah, I forgot the other question. But yeah. No, well, if other states are protecting themselves, does it make sense for Jamaica to also protect itself? Because we're protecting our people. I mean, it's already a very vexed question when the planes come in and people are deported, and on those planes you have persons who have no connection to Jamaica except on paper. They can't find any relative, no one. So the issue of their reintegration, it's not even a it's integration into a society that is foreign to them. And if people are not connected, they can become pawns for organized crime. So that's why I think it may be helpful to hear a little about the data, because I know from my other hats, and not everything can be publicly disclosed, just what the extent of the risk is.
There are many circumstances, and we find also a prevalence of persons who are born here leave when they're before even one, and they go to another country, and now they're 30 or 40, and they are being deported to Jamaica, and these persons have absolutely no connection. Not only that, but we can, in some cases, we can't verify that they are Jamaican. PICA cannot verify that they are actually Jamaican. So even though they might present a document that says that they're Jamaican, there's nobody in the district from where they're from, or any family member who is in Jamaica who can attest to say, yes, this is a family member and this person is Jamaican. So all we have is documentation, and that is a problem. And that is also an issue that is always prevailing. We always have a case. We had one that was languishing for like 3 years, but with the new administration, it was thrust upon us. And that is something that we have to deal with. We now have to integrate that person into Jamaican society, and that is on the burden of the state. In relation to the stateless person, they are afforded rights and privileges under the UN, as far as I know, and they are given a documentation attesting to that, a UN document that attests that they are a stateless person. So really, they travel under.
And who's responsible for them?
The state in which they're in.
Okay.
The application is made through the UN, through that state in which they're in. That's the procedure I know.
Okay.
Yes.
And the second question?
Oh, what was the second one again? Remind me of it.
What was my second question? It was the dissent question. Goodness, I have to go back and listen to figure it out. Sorry, I forgot my second question.
If I may, Chair, we just wanted to clarify. So it wasn't only on the deprivation was not only on the basis of criminal charges, it was also on the basis of that attaining citizenship through marriage or descent through fraudulent documentation.
Or arranged marriage.
Well, which would include fraud. Business marriages are a means of, can be stretched to show a means of fraud, that you would be deprived on that basis, once again, because you are seeking to defraud the state. And as the chair indicated, once you're a citizen of Jamaica, there are far-reaching consequences and responsibilities that the state has. So everybody who claims Jamaican citizenship under the Constitution now has the right to not only freedom of movement and other things, but there are entitlements to you through local government, education, and...
Yeah, I get that. I'm cutting you and I apologize. But the submission that you have, so I get that if you have attained citizenship by descent or marriage fraudulently, if you've and fraudulently would mean not just the fraudulent documents, but under pretense. If you can prove that's something that now has to be subject to some amount of proof. How do you determine that two persons who got married are not? Anyway, I don't want to get into that. That's for another piece of legislation. But my question, but you've said here that an exception should be made for deprivation in cases of persons of descent and marriage who are convicted of serious and heinous crimes and terrorism, allowing for the deprivation of Jamaican citizenship due to the threat of public safety and Jamaica's international reputation. And that is the ground for my question, which I'm asking. Where are those crimes committed that you're asking for this exception to be made? Are those crimes committed under Jamaican law in Jamaica? Are they crimes committed that while captured under Jamaican law are outside of Jamaica, or crimes that are crimes of another jurisdiction that are not Jamaican crimes?
The latter. So it would be you have been convicted in another jurisdiction
state, yes.
of terrorism, heinous crimes, etc., and you are seeking, or you have sought, or you have gained Jamaican citizenship through marriage or descent.
Well, it would have to be you have gained, because you're talking about deprivation. So you already have Jamaican citizenship by descent or marriage, and you're now seeking to remove Jamaican citizenship because they've been subsequently convicted in another jurisdiction.
Correct.
But you don't wish to have the right to remove Jamaican citizenship if they have committed a crime in Jamaica.
No, because that would go through our usual criminal justice system.
I can just, in contribution of that. So, for example, there is in immigration law, Section 4 of the IRCC, the Immigration Restriction Commonwealth Citizens Act. It speaks to a person who, not having received a free pardon, has been in any country convicted of an offense for which a sentence of imprisonment has been passed, and who for this reason is deemed by the minister to be an undesirable immigrant, is not eligible for admission. So if the person would committed a crime and under regular circumstances would not be admissible, then that person then claims Jamaican, to be coming to Jamaica to claim citizenship. You can see the conundrum. So on one hand, the minister would deem them undesirable, but then that same person would then turn around and claim right to Jamaica through marriage or through descent. In a case like that, we're asking that the committee here consider whether or not it is grounds for the person to be denied that citizenship.
I really think it is going to be important to look at your data. I mean, I hear you, I'm sympathetic to it, but I can also see the other side of the coin, and I think of, you know, what do you do with those families, those family units, you know? I get convicted of something abroad. I'm now denied Jamaican citizenship. You know, what happens to those children? I mean, you know, at some point, I see us trying to avoid taking on some burdens and also protecting ourselves from security reasons. But then now you're going to have these children. Who takes care of them? What happens?
Just let me...
I'm just saying, the scenarios I mean, I can talk out the scenarios. I can conceive of the scenarios. So I would be interested in seeing the data and just getting a better understanding of what is grounding the ask.
Let me just say for those who are viewing that increasingly nationality and immigration issues are topical, and they are very sensitive issues. And we have many documented cases which evoke deep emotions. We know of Jamaicans who are sent home, leaving their families behind. And we read in the papers and we see on the television cases that touch our hearts in a real way. We also know that our Jamaicans are a migratory people. And the interest of the state must take the interest of the people to heart. The government of which I am a part is sensitive to these issues. And we want to strike the right balance in protecting what we must protect, because ultimately it's our people that we are protecting. And so there is no easy answers to tough questions and tough issues. There are 3 clauses in the bill under review which seek to provide a revised and clearer framework for our nationality and immigration laws. The provisions are included because we have an appreciation and understanding of the complexity of the matter. what has arisen out of this discussion is whether the provisions need to go a little further to reserve power for the state to take action when appropriate. And I think a good case has been made. That's not the end of the matter, though, because the devil is always in the details, and it would require policies to be formulated and laws to be passed, and for the scrutiny to be done at the appropriate time. And as a member of the cabinet, I'm aware of the laws that are under review. And at the time when the cabinet approved these provisions for tabling, the cabinet was aware that the laws are under review. And that is why, for example, setting out that we need a law to prescribe the grounds on which and the procedure by which a person may become a citizen by descent is included in it. That is why, for example, we have a specific provision which makes it clear that a person can renounce your citizenship. That is your own act. That is what you can do. But when the state is taking action, the due process that is required. So the question which has arisen is, in light of the challenges that are facing us and our own development aspirations, whether the provisions should go a little further to reserve power for appropriate action to be taken in the appropriate case. That is a real question before us. Yeah.
Just one final point. In relation to the rights of persons who are married to a Jamaican, is there a limitation on that? So, for example, the person is now widowed and is now remarried. Does that person still have the right to claim Jamaican citizenship because of the previous marriage?
Let me ask you something. If you emigrated, say to Timbuktu, you fell in love with Timbuktu, and you've built a life in Timbuktu, and you've invested in Timbuktu, and the lady that you marry die, and you've decided that you really have loved Timbuktu so much that you don't want to return to Jamaica, and you don't want to live alone, should you be deprived of your Timbuktu citizenship because the person that you initially marry is no longer?
No, not that you have it, you know.
No, I'm
that
just
you never chose to apply for it while you were married to that Jamaican while they were alive. So when they died, you were still a national of another country. Does that right, because of extent, now that you're remarried to somebody else and now you choose to apply for Jamaican citizenship based on the previous marriage, does that still?
Well, many times people sit on their rights and they only invoke them when they are in danger. Yeah. I'm just saying, we have to balance a number of things. But there can be so many examples which makes it sensible to reserve the power in appropriate cases. But then the law has to be passed. Those matters would not come in the Constitution. The only thing that would come here is a reservation of the power for the Parliament to make provisions. And we set the parameters. Okay. So grounds would have to be specified and procedure would have to be specified. All right. Is there any other matter that?
Just a quick question, which just came to us when we were discussing the issue of the fraudulent acquisition of citizenship. So we were wondering if someone acquires, quote unquote, acquires citizenship by birth, descent, or marriage by fraudulent means, if that person ever really is a citizen, because the documentation that they acquire is simply evidence of a fact, and the Constitution doesn't provide how that fact is established. And so if we establish that the facts are false, and you revoke the documents, then are you really depriving this person of citizenship, or are you simply ascertaining what was always factually not the case?
Mr. Cross, your example has raised another point. The critical importance of people who administer the laws to be well-trained and well-versed. Right? That's really what that raises, because we should know that some things are void ab initio. And if they are void ab initio, it's as if they never happened. And if you acquire something on fraudulent grounds, and fraud is very difficult to prove, then the very foundation is non-existent once it's established that it wasn't there. Because if the premise on which you are entitled, and that's why this gap has to be filled, we must now pass the laws to set out very clearly the grounds on which you can acquire and be deprived, and the procedure that you must go through, because there is a protection of due process. So one of the things that troubles me in this role and in other roles is the high level of ignorance of people working in government. High level of ignorance. And then the government gets a bad name because the people don't know the job. You know, because we're not able to explain properly, and people become frustrated. You make it very clear that if you present fraudulent documents, then you would not have satisfied the criteria in the first place, unless there is a dispute as to whether the document is fraudulent or not. But that becomes another issue. But no one administering a process on behalf of the government can afford to be ignorant of basic things.
I believe, Chair, that the last scenario that you...
Turn your mic off. Turn yours off. Yes.
I believe the last scenario that you placed on the table is exactly one of the reasons why we brought it forward. Because in my contemplation, whenever I'm thinking about legislation, I'm thinking about challenges to legislation in the court. And the investigation that is done by the agency currently does go, to some extent, does do checks as it relates to veracity. However, the question will always be, how were you able to verify this? And then with the issue of actually verifying documents that are far down the line in relation to, you know, dissent and all of that, we wanted to make it very clear. And not only was it, remember we spoke about not only documentation, but fraudulent circumstances. So yes, somebody can assert that in fact I am a citizen XYZ, but we want to make it clear that the state has the power to deprive you once we are able to prove. So that was my thinking, because yes, you would not be a citizen by right because you didn't fill out the criteria in the first place. But that was my, just to make it as clear as possible for a challenge in court if possible.
All right, so those matters would not be set out at the level of the Constitution. The highest we can go is to make the provision to enable the Parliament to make provision. So the question before the committee is whether the framework is to be further revised to reserve a poll, to allow the Parliament to prescribe the grounds on which and the procedure by which a person may become a citizen of Jamaica and a person may be deprived of citizenship, alongside the provisions specifying the procedure by which a person may renounce citizenship. This would mean a significant revision to the framework, the current framework, because it would take out the absoluteness of the citizenship once acquired by certain means. All right, this is a very monumental shift, but it appears that with all that is happening around us, it may be necessary, but the matter will have to be deliberated further. All right? Any other question or comment? May I just say that if you are part of the ministry's legislative team, please move quickly to complete the work, the policy work, Mr. Palmer, outstanding matters, all right? because this is an area that is of critical importance right now. But what all Jamaicans can be assured of is that we will make provisions that are fair and are in the best interest of Jamaicans as we review and reform the Constitution. All right. All right. This is the extent of today's review, because our next meeting will take us into the office of President. And then we will come back to consider the matters on which the committee will make a recommendation. But for members present today who have expressed a view, Member Golden or members online are still experiencing some difficulty. They are hearing but seem not to be able to speak. All right, so the recommendation is for the provisions to be expanded to allow for Parliament to make provisions generally for the acquisition and deprivation of citizenship, and not just in a limited way. And then we will see what the laws, we'll have to then scrutinize what is involved in those laws. All right. How are we with the matrices or the matrix for the view? Right, as we go to, just to give some direction for the remainder, as we go into the review of the Office of President, which is the monumental change, we will take into account submissions that are made to us on those provisions, and then the committee will decide who we wish to hear from if what is sent in is not sufficient to allow us to deliberate on those provisions. We are going to ask the MNS team to follow up with a further memo on the stats. All right? We just want to get a better indication of the challenge that the state faces with persons who are seeking to acquire Jamaican nationality, and particularly in circumstances where they are invoking the entitlement when they are in difficulty and are also entitled to others. And some of the challenges that you have faced verifying the documents to ground applications.
Would it also be relevant to quantify the cost to the state?
Yes.
In relation to persons who are forcibly returned?
Yes.
All right.
Involuntarily returned.
Involuntary return, thank you.
All right. Any other business? All right. Members had expressed a difficulty for tomorrow, so our next date would be next Wednesday. We're not having the 25th. All right, so date and time of the next meeting will be the February 25 at 10 a.m. Wednesday. Wednesday, February 26. Right, thank you, team. We will do our post-meeting at the ministry, post-meeting review. All right, it's now 12:21, and there be no other business. We take the adjournment on a motion by Member Golden. Campbell.
And I can second.
Seconded by Member Charles. Thank you. Member Sinclair, Charles Sinclair. Very well. Meeting is adjourned.